Good afternoon. My name is Mack Rosenberg, and I'm an attorney with over 20 years' experience in products liability and insurance coverage litigation. SB 276, even as amended, is about coercion, lack of due process, and intimidation, as well as invasion of the doctor-patient relationship. The Democratic Party has long been a champion of privacy and individual rights through laws like the California Consumer Privacy Act. But through SB 276, which violates several privacy rights and protections, it's poised to be the party of surveillance over people. Waiver is about voluntary relinquishment of a right, but there is nothing voluntary about this process. To request an ME, a parent must first agree to release her child's medical files to both the Department of Public Health and to the California Medical Board. This is an affront to HIPAA, the federal law that protects medical information, and an end run around FERPA, which prevents schools from releasing students' private information. SB 276 requires that all MEs be submitted to the California Immunization Registry, CARE, with no chance to opt out, despite the opt-out option available to everyone else. There is no valid reason for these privacy violations. Vaccine exemptions have always been within the purview of schools, and there's no history of problems in schools during outbreaks with monitoring that information. SB 276 also violates due process with potentially catastrophic results. First, appealing an ME does not protect a child. SB 276 requires that a child whose doctor has determined upon examination of that child that vaccination may result in injury or death to that child, that the child be vaccinated during the pendency of their appeal. Second, there's no unbiased review and appeal process. The only people reviewing MEs and appeals of denials are either state employees or those appointed by the Secretary of Health and Human Services, and the Secretary has the final word. Children will have their medical exemptions denied or revoked. They'll be deprived of the fundamental right to attend school and have no ability to go to court to appeal the Secretary's denial of their medical exemption. With respect to SB 276 requirement that DOH review reports from schools to identify schools with the lower than 95% vaccination rate, this is regardless of the medical exemption rate in those schools. That rate is less than 1% statewide. It creates an unnecessary financial and time burden on both the state and the schools, and it doesn't address the real reasons that some schools are below that 95% rate. Approximately 20% of schools are classified as not up to date or below 95%. But 92% of those schools have fewer than 4 medical exemptions in their schools, and more than half have 0 medical exemptions. So what's happening in those not up-to-date schools? Those numbers are lower because of conditional entrance and overdue students, students who have nothing to do with medical exemptions. And what about investigating doctors who write more than 5 MEs per year? This arbitrary number appears to arise from a baseless assumption that doctors who write MEs are engaging in unprofessional or fraudulent conduct. It fails to account for pediatric specialists who treat vulnerable children, and it fails to account for different practice sizes. For example, your ceiling is 5, regardless of whether there are 200 children in your practice or 2,000 or 10,000. Doctors may be forced to pit patients against each other in weighing who should receive one of these few coveted exemptions in order to protect their practices. And notwithstanding claims that unscrupulous physicians are selling exemptions, despite dozens of complaints, the California Medical Board has not disciplined a single physician for writing an exemption pursuant to SB 277. In fact, it's been demonstrated in earlier testimony that the board has available to it means to obtain medical records if they feel they need to do that. Many of the physicians that SB 276 seeks to intimidate and censure are actually ahead of the average physician in their understanding of vaccine injury, epigenetics, genetic susceptibility, and autoimmunity. They keep up on emerging science, and they make patient-centered decisions based on precision medicine. It would be a disservice to this state, to its physicians and its citizens, to censure and intimidate those physicians who are practicing medicine according to the most up-to-date science. It flies in the face of the Business and Professional Code, which recognizes the importance of protecting doctors in the forefront of medicine. And it represents a huge step backwards from precision, patient-centered medicine. I urge you to abstain or vote no on SB 276.